Did you know that in California, if you die without a will, the state could decide who gets your house, your savings, even your family heirlooms? And in some shocking cases, your spouse or kids might end up with absolutely nothing. That's not just a scary possibility, it's a legal reality for thousands of families every year. Even worse, some laws were just updated, and most people have no idea. You could be doing everything right, thinking your family is protected, only to find out too late that a small oversight, like forgetting to update a beneficiary form, has left your entire estate in the hands of an ex-spouse, the government, or people you've never even met. It's happening right now across California. In this video, we're diving into 10 shocking inheritance laws that could completely wipe out what you've worked your whole life to build. Stay until the end. Your family's future may depend on it. Number 1. No will. The state decides everything. Most people assume that when they pass away, their assets will automatically go to their spouse or children. But here's the truth. If you die in California without a will, also known as dying intestate, the state steps in and takes control of everything. Not your family, not your best friend, not even your longtime partner. The government becomes the decision maker. Here's how it works. Under California's intestate succession laws, your estate is divided based on a strict legal formula, one that doesn't consider your relationships, your wishes, or your family dynamics. For example, if you were never legally married but lived with your partner for 30 years, they get nothing. If you're estranged from your parents but have no children, your entire estate could go to them, even if you haven't spoken in decades. Even more shocking, the process often leads to delays, legal battles, and unexpected heirs coming out of nowhere to claim a share. Families are torn apart, assets are frozen, and what should have been a smooth transition becomes a painful and expensive nightmare. All of this can be avoided with a simple legal document, a will. It's not just for the wealthy, it's for anyone who wants control over their legacy. Creating a will lets you decide who gets what, when they get it, and how it's handled. Without it, you're handing over that power to the courts and hoping for the best. We pour hours into creating helpful videos like this one. All we ask in return is one click. If this opened your eyes, subscribe now and drop a comment below. Have you written a will yet? What's holding you back? Number 2. Stepchildren usually get nothing. Here's a heartbreaking truth. In California, stepchildren are not legally entitled to inherit anything unless they've been formally adopted or specifically named in a will or trust. That means you could raise a child for 20 years, love them as your own, support them through every milestone, and when you pass, the law sees them as a legal stranger. It doesn't matter how close your bond is or how much they meant to you. If your estate plan doesn't include them, they're completely cut off. This often comes as a devastating surprise, especially in blended families where step-parents and stepchildren have deep, genuine relationships. Even worse, if your biological children are listed and your stepchildren aren't, it can create painful family rifts, resentment, and even legal disputes. One sibling ends up with everything, while the other, equally loved, is left out, not because you wanted it that way, but because the law didn't recognize your intent. And here's what most people miss. Verbal promises won't protect them. You can tell your stepchild, "Everything I have is yours someday," but unless it's legally written down, those words won't hold up in court. The solution? Name them in your will or trust, clearly and specifically. You can even write a letter of intent or video message to explain your wishes. It's a small step that prevents big heartbreak. It takes a ton of research, care, and love to bring you videos like this. If you're learning something new, do us a small favor. Hit that subscribe button and tell us in the comments, do you believe stepchildren should automatically have inheritance rights? Number 3. The community property rule can override your wishes. You might think your will is the final word on who inherits what, but in California, even with a will in place, the community property law can override your decisions, especially in marriage. Anything you acquire during your marriage is automatically split 50-50 with your spouse, regardless of what your will says. Sounds fair? Not always. Let's say you own a business, investment property, or have savings you intended to leave to your children from a previous marriage. If those assets were accumulated while you were married, your current spouse could legally claim half, even if you meant for it all to go to your kids. The law views it as marital property, and your intentions may not matter in court. This rule has blindsided countless families. Children feel cheated, spouses feel betrayed, and what could have been a peaceful inheritance becomes a courtroom battle, all because the estate plan didn't account for California's community property laws. Even separate property, assets owned before the marriage, can become partially community property if they were commingled or improved using joint funds. That house you bought before the wedding, if you used shared money to renovate it, your spouse may be entitled to a piece. The best way to protect your wishes? Work with a lawyer to create a detailed estate plan, including a trust and possibly a postnuptial agreement. These tools can legally separate assets and ensure that your intentions are honored, not overruled. We put serious time and heart into making videos that truly matter. If this gave you clarity, smash that subscribe button and tell us in the comments, have you ever heard of the community property rule before today? Number 4. Verbal promises mean nothing. You can promise your niece the family jewelry, your best friend the classic car, or your nephew the lake house. But if it's not written down and legally binding, none of it matters. In the eyes of California law, verbal promises are meaningless, no matter how heartfelt or how many people heard them. This is one of the most common and painful inheritance disputes. A relative passes, and suddenly multiple family members claim, "They told me I'd be getting that." But without proof, the courts will follow only what's on paper. Or worse, let the assets fall under default inheritance laws. It doesn't matter if it was a deathbed wish or a lifelong promise. If it's not in a will, a trust, or a properly documented legal document, it's not enforceable. And here's where things get messy. When expectations aren't met, emotions flare, and families are often torn apart by lawsuits, accusations, and years of bitterness. Even worse, sometimes the person you trusted to do the right thing after you're gone might suddenly change their mind or feel pressured by others. Verbal agreements offer zero protection when money, property, and emotions collide. The fix is simple but powerful. Put everything in writing. Create a will. Set up a trust. Use clear, legal language to spell out who gets what, even for the small stuff that holds sentimental value. It's not just about legality, it's about peace of mind for everyone you love. If this video is helping you protect your family's future, show us some love with one quick click to subscribe. And drop a comment. Has someone ever promised you something valuable but never put it in writing? Number 5. Ex-spouses may still inherit. Here's a nightmare scenario. You go through a tough divorce, rebuild your life, and move on. Years later, you pass away, and your ex-spouse ends up inheriting your life insurance payout, retirement funds, or even your home. Sounds impossible? It happens more often than you'd think. In California, many people forget to update their beneficiary designations after a divorce, and the court doesn't automatically fix that for you. So if your ex is still listed on your 401k, life insurance policy, or transfer on death deed, they might legally receive those assets, even if you're remarried or had no contact for years. Imagine your current spouse or children finding out that your ex just got a $500,000 life insurance check simply because you forgot to change one form. It's not only financially devastating, but emotionally crushing for the people you love most. And here's the kicker. Your will can't override beneficiary designations. Even if your will says everything should go to your new spouse or kids, the company holding your policy will follow the last beneficiary form on file, no questions asked. The fix? Review and update your beneficiary forms regularly, especially after major life changes like divorce, marriage, or the birth of a child. Don't assume your divorce decree took care of it. Inheritance law doesn't work on assumptions, it works on paperwork. We dig deep into the laws that could change your family's future. All we ask is one small thing. Hit that subscribe button to support the work behind these videos. And tell us in the comments, have you double-checked your beneficiary forms lately? You might be surprised who's still listed. Number 6. The state can take it all. Escheat law. What happens if someone dies in California and no legal heirs can be found? You might think the state tries harder to track down distant relatives, but in reality, under California's escheat laws, if no rightful heir is identified, the entire estate can be claimed by the state itself. Yes, that means everything: money, real estate, family heirlooms, and personal possessions. Gone. And it doesn't just happen to billionaires with hidden fortunes, it happens to ordinary people, especially those who are single, childless, or estranged from family. Imagine working your entire life, saving carefully, building something to leave behind, only for it to be absorbed into the state's treasury simply because you didn't name a beneficiary or create a will. It's a tragic and surprisingly common ending to a life's work. And here's the twist. Sometimes heirs do exist, but no one knows how to find them, or the deceased never told anyone about them. In other cases, people assume assets will automatically go to someone, but without legal documentation, they don't. The law doesn't care about assumptions, only what's proven. So how can you protect your estate from escheating to the state? It's simple. Create a clear estate plan. Name your heirs. Update your documents. Even if you think you have nothing big, having a basic will or trust can stop your legacy from disappearing into government accounts. We work hard to break down complex laws into simple, life-saving tips, and your support means the world. Click that subscribe button to help us keep going, and tell us in the comments, would you rather your assets go to a distant relative or the government? Number 7. Children from previous marriages may be left out. In today's world, blended families are more common than ever, but here's a painful legal truth. Children from previous marriages can be completely disinherited, unintentionally, if your estate plan isn't crystal clear. Here's how it happens. You remarry, thinking your new spouse will do the right thing and share your assets with all the kids, including those from your previous marriage. But under California law, if you don't name your children in your will or trust, they could get nothing. Everything may legally go to your current spouse, who then has full control and no legal obligation to pass anything on. Even if your new spouse promises to take care of them, circumstances can change. Remarriage, falling outs, financial struggles, all of these can shift priorities. And suddenly, the kids you meant to protect are left out in the cold. It's not about trust, it's about protection. The law won't assume you wanted to include all your kids unless you explicitly say so. In some cases, if a child was born after your estate plan was created and isn't mentioned, they might not receive anything at all. The solution? Use a living trust or detailed will that clearly includes all your children, no matter when or from which marriage they were born. You can even create specific instructions to ensure fairness and avoid future conflict among heirs. Don't let silence be the reason someone you love gets left with nothing. It takes real dedication to uncover and explain laws that affect your legacy. If this opened your eyes, subscribe with one quick click and help us grow. Comment, share. Should stepkids and children from past marriages have equal inheritance rights? Let's talk about it. Number 8. Probate can eat up your estate. You've spent years building your assets, your home, your savings, maybe a small business. You want those things to benefit your loved ones when you're gone. But here's the harsh truth. If your estate goes through probate in California, a huge chunk of it could be lost to legal fees, court costs, and delays. Probate is the court-supervised process of distributing your assets after death. And in California, it's not just slow, it's expensive. Attorney and executor fees are calculated based on the gross value of your estate, not the net after deaths. That means if you have a $600,000 house with a $500,000 mortgage, the fees are based on the full $600,000. You could easily lose 5% or more of your estate, tens of thousands of dollars, just to process it. And that's not all. Probate cases can take 6 to 18 months, or even longer if the estate is contested. During that time, your loved ones may be blocked from accessing money they need, dealing with mountains of paperwork, and waiting while the court moves at its own pace. All of this can be avoided or at least minimized by creating a revocable living trust. Unlike a will, a trust doesn't go through probate. It puts someone you trust in charge, allows assets to transfer privately and quickly, and can save your family thousands. Don't let your legacy get buried in red tape and fees. Plan ahead so your family doesn't have to pay the price later. We pour hours into researching and simplifying these topics so you don't have to. If this helped you, please subscribe with one simple click and let us know in the comments, did you know probate could take so much of your estate? Number 9. Undue influence can invalidate a will. You may think your will is rock solid, carefully written, signed, and witnessed, but did you know that someone could challenge it in court and have it thrown out, all by claiming you were influenced or manipulated when you made it? In California, this is called undue influence, and it's one of the most common reasons wills get contested and invalidated. If someone convinces the court that you were pressured, tricked, or mentally vulnerable at the time your will was created, the entire document could be dismissed. That means everything you planned, who gets what, how things are divided, could be reversed. This often happens with the elderly or those in poor health. A caregiver, family member, or even a new friend swoops in, gains trust, and suddenly manipulates the situation to benefit themselves in the will. Sometimes it's not even obvious, a slight suggestion here, a guilt trip there, but it can be enough to sway decisions. If challenged, your loved ones may have to defend your intentions in court, facing legal fees, emotional stress, and delays. And in many cases, the person you wanted to protect ends up with nothing. To prevent this, make sure your estate plan is created with a qualified attorney, ideally with multiple witnesses, clear mental capacity assessments, and written explanations for your choices. You can even include a video recording of your signing, showing that you are confident and in control. Protect your will not just from mistakes, but from manipulation. We go the extra mile to bring you real, eye-opening facts that others overlook. If this helped you see the hidden risks, subscribe with just one click and tell us in the comments, do you think wills should require proof of mental capacity to be valid? Let's hear your thoughts. Number 10. New laws mean your old will may not be enough. You made a will years ago, tucked it away, and checked it off your to-do list. But here's the problem. California inheritance laws are constantly changing, and if your will hasn't been updated in a while, it could be outdated, incomplete, or even invalid. Many people assume a will is a set-it-and-forget-it document, but over time the laws evolve, and so does your life. You may have gotten married or divorced, had children or grandchildren, bought property, or lost loved ones. If your estate plan doesn't reflect those changes, your assets might not go where you intended, or worse, end up in probate. Even worse, California has passed several inheritance and estate planning law updates in recent years, especially concerning digital assets, trust transparency, and spousal rights. If your documents don't comply with current legal standards, the courts may ignore them, leaving your family vulnerable to delays, confusion, or legal battles. And remember, outdated documents are often just as dangerous as having none at all. That simple will you wrote a decade ago might not protect your blended family, account for new assets, or prevent taxes and fees that didn't exist back then. The solution is simple. Review your estate plan every 3 to 5 years, and always after major life changes. Sit down with a trusted estate attorney who's familiar with California law. It's not just about paperwork, it's about making sure your wishes still stand in today's legal world.
We create these deep dive videos to protect you and your loved ones from costly mistakes. If this gave you even one aha moment, support us with just one click. Hit subscribe and tell us in the comments, when was the last time you updated your will? Be honest.
If there's one thing this video should make crystal clear, it's this. When it comes to inheritance in California, what you don't know can hurt you and your family. The laws are complex, often misunderstood, and can change without warning. And without a solid, updated estate plan, everything you've worked for could end up in the wrong hands, or in the hands of the state itself. We've covered 10 shocking legal truths, from how stepchildren can be left with nothing, to how an ex-spouse could inherit your assets, to the reality that outdated or verbal promises simply don't hold up in court. These aren't rare loopholes, they're happening every day to everyday people. Don't assume you're safe just because you have a will or think you're not rich enough to worry about it. The good news? You still have time. With just a few smart steps, like creating or updating a will, setting up a trust, and reviewing beneficiary forms, you can take full control of your legacy. You can protect your loved ones, avoid unnecessary legal battles, and ensure that your final wishes are honored with dignity.